My name is Alan Cheng. I'm a lawyer licensed in Ontario. I'm currently practicing family law, civil litigation, and immigration law with Saw Law Professional Corporation. And before I begin, I just would like to put a disclaimer that this is purely for informational purposes and should not consider as legal advice for what I say in this video. The matrimonial home is a special status that is given in Ontario's family law. As defined, every property in which a person has an interest, that is, or if the spouses have been separated, was at the time of separation ordinarily occupied by the person and his or her spouse as their family residence, is their matrimonial home. First, every property. Every property means that this residence does not need to be a home or a house, as one would think. This one can be an apartment, a condominium, or even a boat, or even a trailer. So it's anything where one may consider a property where they can use as a residence. The second criteria, it is in which a person has interest. An interest is a term to describe any right, claim, or privilege that a person may have towards that property. And typically it is the property interest can be either as an owner or as a tenant. For the third criteria, that is or was at the time of separation ordinarily occupied. That means that you and your spouse must have lived in the property and used as a family home. It is one where you have ordinarily reside in during your marriage. And then that the amount of time that you spend at this property, it is an important factor to consider. You do not need to be in the matrimonial home, say, for the whole year, for all the time. You're allowed to, you can have, cottages where you spend some time away. So it is, but then it is based on what you would consider what you ordinarily reside in. So it's not a vacation home and not something that is temporarily either. The matrimonial home, it only applies for married couples. It does not apply to common law partners. So for a matrimonial home, typically a couple would only have one, as the matrimonial home is their main asset and main residence as well for them. But as you mentioned, it does not mean that there is a cap on matrimonial home. A person can have more than one matrimonial home if they're able to define and show that it is one where they have an interest in, and it's a property where they ordinarily occupy and treat it as the family home. So, for examples of a matrimonial home, I think one that people may face is if you were to live on a farm. And when you live on a farm, what is considered the matrimonial home? The matrimonial home, as we discussed, is the place where you ordinarily reside. So if you operate a farm and live on it, the portion in which you use for residential purposes may be considered as a matrimonial property, whereas the commercial parts of it cannot. Another example of matrimonial home is if there is a property that you may travel to outside of the country year-round. For example, there are people who own condos in Florida. So if the parties consider that as a place they ordinarily reside as well, then that condo in Florida can also be considered as a matrimonial home. So in this type of situation, if you do have a condo in Florida, you do also have a residence in Canada where you normally live in for the rest of the year. The condo in Florida can also be considered a matrimonial home. So this is one of the cases where you mentioned before where someone may have more than one matrimonial home. The next topic is the right of possession and alienation of the matrimonial home. As discussed, the matrimonial home is given special considerations unlike any other property. A few examples would be that there's an equal right to possession of the home for both spouses, even after separation, even where only one spouse has an interest in the property. Even if the property is only under one of your names, even after separation, both of you still have the right to live within that property. There's also restrictions on the matrimonial home. So in separation for the matrimonial home, a party cannot unilaterally dispose of the home. And by dispose, that just means to sell the home or to getting rid of the property or to place mortgages or further encumbrances on the property without the consent of the other spouse. And the third special consideration is that the court is able to make possessory orders respecting the home, including the order for exclusive possession and order regarding conduct. So this one is honestly a very important one, especially in the cases of violence and domestic abuse. The court with a matrimonial home can order that have one party to be in the sole possession of the home. So the court can order that only one party live in there, say with the children, and that the other party has to move out and live elsewhere. So even if you don't have children, the court can still make an possessory order, as in cases where domestic violence, where the parties need to be separated. The court can order that for one party to be in possession of the home and for the other to find living arrangements elsewhere. There's also another special consideration given to the matrimonial home, and that's the automatic severance of a joint tenancy upon death, where the home was owned by the deceased spouse and a third party. Joint tenancy, this one goes into real estate law. Upon death, the right of one joint tenant automatically passes on to the other. But in this case, if your spouse owned the home with a third party, as mentioned, who's not your spouse, if this was not in place, you would essentially lose any interest in your home. So by being a matrimonial home, this protects the surviving spouse's interest in the case where one spouse were to become deceased. And lastly, there's the inability to deduct the value of the matrimonial home on the date of marriage. The right of possession we already discussed earlier, in that the spouses have equal rights of possession to the property. This is regardless of who the name this property is in, but even after separation, both spouses are still able to live in that property. Since both spouses have a right to stay in the matrimonial home, I offer certain safeguards, such as that neither can sublet it, rent it, or sell it without the other's permission. This is made so that it protects either spouses essentially to not become homeless during separation. The right of possession is only applicable against the spouse. So what this means is that there is no additional interest in the property by the spouse, which also means that this right of possession only lasts during the party separation. And this is also before the divorce is finalized. Of course, there are certain exceptions where this right can be preserved either through a separation agreement or by a court order. If there is no separation agreement or a court order, and the parties do receive the divorce, then there is no longer the right of possession to the matrimonial home. It depends on the original interest of the property as well, whether the property was only in one party's name or was it in both parties' name as well. Because if both parties do already have an existing interest, then they both already have an existing right for possession. So in a case where one party does not have an interest in the property and only has possessory rights, typically these issues are resolved prior to divorce. So before divorce is issued, the court would often deal with these possessory rights issues, and as mentioned, often these rights are dealt with earlier on, whether through agreement by the parties or through a court order. For the matrimonial home, as we discussed, it has a special status and consideration. So the party cannot contemplate essentially to contract away or give up this right during their marriage contract. So for example, in a prenuptial agreement, even if you have a term saying that you will forego any of the interest in the matrimonial home, such clause will not be upheld by the court.